This is easy. May it please my lady and my lords. Immediately before lunch, I was within part 2 of my submission, just outlined the 5 headline points that I was going to deal with in relation to the features of the statutory scheme that I'll be submitting are inconsistent with the expansive approach to indirect service. May I start on the first one of those, which is the deemed taxation context. Before I get into the critical statutory provisions, which is section 46A and schedule 4A, may I just take a brief step back? I'll do this by reference. There are a couple of statutory provisions that aren't in the authorities but are mentioned. I think they're uncontroversial, but we have context in the decisions below. So if I could do it by reference to a couple of references in the decisions below before I go into the completion notice regime. So if the court could please go first of all to page A161, which is within tab 13. And that's the decision of the Upper Tribunal Lands Chamber. And just paragraph 12, Mr. Roger, the Deputy President, refers to section 42 of the Local Government Finance Act 1988. Each non-domestic hereditament must be shown on the local non-domestic rating list maintained by the valuation officer for each billing authority. So the statutory scheme is, as is well known, section 41 is the duty on the valuation officer to maintain the valuation list. Section 42 is the requirement for the valuation list to show each non-domestic hereditament. And then, and I apologise for jumping around, but if you go to the Court of Appeals decision, which is within tab 12, and to paragraph 13 of that at page A141, we see the important point of context that both liability for unoccupied rates under section 43, for occupied rates under section 43 and for unoccupied rates under section 45 has one of their statutory preconditions that the hereditament is shown in the list. So that's the context in which this deeming provision operates. And another point of background context is when does a new building become a hereditament? And there is a settled position on that. It's actually recorded as an agreed fact, both in terms of the approach and in terms of the application of that approach in this case, in the statement of facts and issues at paragraph 12 and paragraph 24. If I could just show those briefly. So the statement of fact and issues is tab 4, and at A44, paragraph 12, the statement of facts and issues records there's no basis for entering a nearly complete building into the rating list other than through the completion notice procedure. And you'll see that's by reference to a case of Porter and Gladman, paragraph 66. I will show you that very briefly because that's an important part of the context. But then it's also common ground in this case, see paragraph 24, that the physical state of the premises on the 1st of June 2012 was such that it could not have been entered into the rating list without reliance being placed upon the deeming effect of a completion notice served in accordance with the mechanism contained in section 46A and schedule 4A of the Act. So that's the context and its application to the facts of the completion notice provisions. May I just spend literally one moment on Porter, unless my lord. Porter is behind tab 45, and it's a decision of the then president of the Lands Tribunal, Mr. George Bartlett, Queen's Counsel, together with the experienced surveyor member Norman Rose. It concerns whether an office building could be entered into the rating list in circumstances where the completion notice procedure had not been followed. And there's a fairly extensive review of a number of authorities that take place in the decision, which start effectively, the conclusions start at page A466 of the bundle within tab 45. That there is an authoritative review of the relevant authorities, but then the principle is encapsulated very pithily and accurately at paragraph 66, which is A476. And the Lands Tribunal say the authorities in our judgment establish the following: a building is only a hereditament if it is ready for occupation, and whether it is ready for occupation is to be assessed in the light of the purposes for which it is designed to be occupied. If the building lacks features which will have to be provided before it can be occupied for that purpose, and when provided will form part of the occupied hereditament and form the basis of its valuation, it does not constitute a hereditament, and so does not fall to be shown in the rating list. There is in consequence no scope for including in the list a building which is nearly, even very nearly, ready for occupation, unless the completion notice procedure has been followed. So that's the statutory function of
once it's complete, what then?
Well, once it's complete, then it doesn't need to get if we're dealing with an as complete building, the completion notice procedure is clarificatory, but it can be entered into the rating list.
So the procedure then is just simply for the valuation officer to enter it into the list on the basis of a proposal by someone to vary the list.
Yes, or in fact, effectively the section 41 power to maintain the list. But in the circumstance that my Lord's contemplating of an as complete building, there are two options. One is the valuation option. The valuation officer acts of his own volition and enters it, and then there could be a proposal, but if it's found that that's complete, applying the Porter test, it wouldn't be deleted. But there is the ability in that circumstance for the billing authority to serve a notice that they form the view that it's complete and it's clarificatory, it's deemed to be complete and put beyond doubt. So in that context, the completion notice procedure does apply, but it applies in a confirmatory manner to put the matter beyond doubt. If we're dealing with a not yet complete building, including a very nearly complete building, this tells us the valuation officer can't put it in the list. The only way it can go in the list is through the triggering of the section 46A and schedule 4A mechanism, the deeming complete notice. We are in the territory of a deeming complete because nobody's saying that as it existed on the ground, it was complete, but the issue is whether they had effectively taken account of the statutory deeming mechanism to deem it to be complete, both for the purpose of entry into the list and for the purpose of valuation. And the importance of realising that, I say, is that it's a double disadvantage to the ratepayer, but also it's to understand that a third official, or a second official, a third actor, the valuation officer, needs to understand that this mechanism has been effectively undertaken, because this is a way of setting a deemed state of affairs that the valuation officer has to act on by altering the list pursuant to his duty under section 41 and the mechanism in section 42.
That's always the case. He's always got to find out from someone what's happened.
Yes.
And it may or may not be by virtue of service under the statutory provisions. It may be by
that's right.
Service outside the statutory provisions.
That's right. The distinguishing feature, I say, of this is that this is a deeming provision with a mechanism, and the only point I make at this stage of the discussion is that it's not a bylaw. If we contemplate the purpose of that notice in the language of landlord and tenant, its purpose is to communicate the billing authority's view to the recipient. True, but not a complete explanation of its purpose, is my point, because it also has a purpose of fixing a state of affairs under the mechanism that is A, to the disadvantage of the ratepayer, but B, must be acted upon by the valuation officer.
Unless it's appealed under paragraph 4.
Yes, they must act on the outcome of the Schedule 4A process, which is either that the notice has effect or that it's postponed until the appeal has been determined, my lord. But yes, subject to that qualification, that's right. But the point, I say, is that this doesn't sit in a purely bilateral dialogue. It sits in a statutory mechanism where it's fixing something that requires certainty and also requires that to be actively communicated to another public body, the valuation officer.
So can you assist us in relation to the role of the valuation officer and at what stage he comes to depend on the process having been invoked correctly?
Yes, so the role is Section 41 of the 1998 Act gives him a statutory duty to maintain the list. And as we'll see when we look at the detail of Schedule 4A, when my learned friend took you through it, he said, oh, we don't need to deal with Para 7, don't criticise. But you'll see, if we just look at Para 7, you'll see that built into the scheme is a process of communication with the valuation officer, which I'll show you in just a moment.
Thank you.
But does that answer it sufficiently
Yes,
for now?
I was jumping ahead.
So that's Porter, again, before I just look at the provisions of the scheme, it is helpful to have in mind that there are effectively two types of completion notice: the confirmatory as complete and the deeming. Now, we're concerned with the deeming, but in terms of understanding how service needs to work, one of my submissions will be that the approach to service has to be capable of working for both notices. And so it's necessary to look at to a limited extent, how the other type of notice operates as well, because it's not suggested that there's a different regime depending on the notice. So with those introductory observations, may I look at the specific statutory provisions? And so we're in the bundle, we're behind tab 27, and we're at page A221, please. And so section 46A, subsection 1 gives effect to Schedule 4A, and subsection 2 indicates where a completion notice is served under Schedule 4A below and the building to which the notice relates is not completed on or before the relevant day, then for the purpose of section 42, which is the entry into the list, and Schedule 6, which is valuation, the building shall be deemed to be completed on that day. I think that's all that we need from 46A. We then go to Schedule 4A, and I know my learned friend has shown the court this, but its provisions and the way it operates is essential to the shape of my argument. So I do want to identify one or two of the provisions that I say are of importance. So paragraph 1.1 is dealing with the type of notice that we're concerned to in this case. It's the deemed completion notice, and the statutory language there refers to, if it comes to the attention of a billing authority that the work remaining to be done on a new building in its area is such that the building can reasonably be expected to be completed within 3 months, the authority shall serve a notice under this paragraph on the owner of the building as soon as is reasonably practicable, unless the valuation officer otherwise directs in writing. Now, Lady Justice Gloucester's 3 requirements in paragraph 44 of her judgment, in judgment of the Court of Appeal, are plainly there on the face of the statute from the billing authority serving the notice under this part of the statute on the owner. There's a different worded provision in terms of where the authority forms the opinion that it has been completed, because that's confirmatory in its effect, but that's subsection 2. I'll come back to that distinction in just a moment. Paragraph 2 is concerned with the mechanisms for, or the requirements for a completion notice, and the approach to serving in subparagraph 2 a deeming notice. And in subparagraph 3, can I just invite attention to this, because I'll come back to it in just a moment in the argument, where at the time a completion notice is served, it appears to the authority that the building to which the notice relates is complete, the authority shall propose as the completion day the day on which the notice is served. So for the confirmatory notice, I appreciate we're not directly concerned with that, but for the confirmatory notice, the date on which the notice is served is absolutely critical, because it is the completion date. So it must be ascertainable with complete certainty. Now, my submission is that a regime of indirect receipt that allows for a lag in time, where it goes via an unauthorised agent, there may or may not be a delay and it ends up somewhere else, won't work and can't have been contemplated under that provision. Now, I say two things follow from that. Firstly, it would be absolutely surprising if there was a different approach to service for the two notices. And secondly, it would be even odder if there was a more permissive and lax approach to the requirements of service for the deeming one to the one that actually is confirmatory in effect. So the idea that the indirect receipt approach doesn't work if there's a lag in relation to the confirmatory notice is, I would submit, an indication that the expansive and open-ended potential approach of eventual receipt is not something that's compatible with the need for certainty in this statutory regime. The other provisions of the...
I'm not sure what... in subsection 3, presumably the authority will put on the notice the date when they actually send it.
Well, they are...
service...
In practice...
In that sense, of what they're doing.
In practice, they might personally serve it so that they know exactly that it's there, or they might make a calculation and explain that it's to be deemed service relying on one of the particular mechanisms in paragraph 8. But either way, it undoubtedly requires a certain and ascertainable date of service at the time that the notice is prepared.
All I'm saying is I wouldn't, for myself, assume that service there is referring to receipt. I would have thought it's much more likely to be referring to the act, their act, in initiating the process. But I mean, we're not asked to decide that. But
in subsection 3?
Yeah.
But my submission is not, because if it was received after the completion date that had been identified in the notice, then it wouldn't be prospective. And
they can have an argument about that, and someone will have to decide it. But I don't think we can assume.
We don't have to decide it.
No.
We may not make any assumptions one way or another. There is, incidentally, is there not, a misprint in subsection 2?
In subsection 2 of
paragraph 2.
Paragraph 2, there's
fairly obvious misprint.
Purpose.
Purposes rather than propose.
Yes. There is another misprint in the statutory provision, actually, which I won't take time on, but it's not a terribly well-crafted
That
piece
one
of
is
legislation.
perhaps a little bit important, because
Yes.
you're relying to some extent on the comparison between subparagraph 2 and subparagraph 3.
Well, my lady, less so. My point is that the approach to service has to be capable of working and making sense in 2.3 and 2.2.
In both of those
Yes,
cases.
yes.
Mr. Kalinsky, how does this distinction then work in relation to the stipulated methods of service in paragraph 8 of the schedule?
Well, there is no...
Is it known precisely when service is effected in each of those?
Well, it certainly would be in relation to C, I think
Yes, when you nail it to the wall of the building.
yes.
And you take a photograph on your phone showing when you did it.
But in relation to the others, I think the practical approach might be to take account of the provisions in the Interpretation Act for deemed for deemed receipt when post is used, so that it could be known. So what you would do is effectively you would give the benefit of the doubt. So you would put in the deemed date of receipt as the date. So if you were posting it and you were allowing 2 days under the deemed provisions, forgive me, I'm not certain if that's right, but you would effectively count forward 2 days.
Ordinary course of post, I think, is the phrase.
And you would form your view, and therefore at the point at which you prepared it, you would be able to say with certainty what the date of service would be. And if it was actually received before then, it wouldn't offend, I would respectfully suggest, a statutory scheme, because it would be received before the identified completion date.
Thank you.
And then, so the other features of the scheme that I just wanted to identify is the communication with the valuation officer being built into it. So that is paragraph 7. The billing authority has a series of positive requirements effectively to keep the valuation officer appraised of critical developments. So supplying a copy of the completion notice that's been served by it. Now, obviously, if we just think about the as complete notice, that will be a completion notice that identifies the date of service in the notice. And that's obviously important, because the valuation officer acts on that by entering it into the list on that date. In the deemed provision, it would identify a future date under paragraph 2.2, but the judgment that's required at the time at which a completion notice is served is the authority has to form a view under paragraph 1.1 about the state of the property and whether it can be completed. And the view that's being formed is by reference to the service of a notice. So I would also submit that the scheme is not contemplating a lag between the acting on that view and the service of the notice, whereas my learned friend's argument absolutely depends upon the fact that there can be this open-ended gap between those two dates. And I say that just doesn't work in this statutory scheme for either notice. It's more profoundly obvious quite why it doesn't work for the as-complete notice, but equally, once one understands the mechanism, I say it doesn't work for the deeming notice either. And the other provision is obviously, I readily accept the words without prejudice to any other mode of service is permissive to that extent, and I don't dissent from the lines drawn by the Court of Appeal, who rejected my submission that it had to have a statutory foundation and expressly contemplated service agreements by agreement and by service on authorised agents. No part of my argument to dissent from that, but I say two very significant extensions here that don't work in this scheme and have no authority lying behind them, and that is the idea of indirect receipt, where it passes through an unauthorised agent who isn't authorised to receive it and can't be authorised to serve it. That's a wholly unprecedented step actually on any authority, and certainly on any authority in this context. And secondly, I will say, as I develop my submissions, that the fact that the accident of the consequences of the attempted service here ended up in the actual original notice being misplaced and only an electronic notice being received is in itself fatal to there being effective service, because I say there's clear regulations across this statutory scheme that only allow for electronic service in limited circumstances and on a consensual basis. And we're not in those circumstances. We're in a materially different context to those circumstances, and there's no consent.
So have I understood correctly that you say that paragraph 8 extends only to a method of service which is prescribed by statute or by agreement between the parties?
When I formulate what I was intending to formulate later on is that it's not necessarily that restricted. So I align with what the Court of Appeal said, which is those two definitely consensual authorised agents. I would accept that it would also cover an act that could be properly described in the terms that Lady Justice Gloucester formulated them in paragraph 44 as service by the authority on the owner. But that requires directness, and it does not extend critically to through an unauthorised agent for the two reasons of they're not authorised to receive and they're not authorised to serve. So the formulation that I will, in answer to my Lord Carnworth's request of Mr. Coquelin, that it would be helpful to have some clear parameters. Yeah. The clear parameters I offer are, and will be referenced by reference to paragraph 52 of my case, but they are effectively on all fours with what I say the Court of Appeal held, which is any statutory method, authorised agent, and anything that can properly be described as service by the billing authority on the owner. The critical point being the case law that says the authority must effectively control any agency arrangement that can properly be termed as service on their behalf. That's the Credit Suisse case that's referenced in my case at paragraph 52. So it's what I say is wrong here is that they had no control when they left it with the receptionist. That is not causing the notice to be served. It's not being directly served. It doesn't work as a matter of law because the receptionist couldn't possibly have been authorised to effect service on behalf of the authority as a matter of law, and obviously there's no finding that they were as a matter of fact either.
But otherwise you exclude all of the common law possibilities of service.
Well, the submission I make is that that one has to be very careful about the concept of a common law principles of service, because it begs the question, in what context? And the context in which my learned friend draws from is a bilateral arrangement between landlord and tenant with no overall context, not a statutory body exercising public law power, not a taxation context. So I say context is everything, and the context here is one where taking that broad permissive approach, which actually is only based on an obiter dicta in Townsend, that I say on a proper analysis isn't necessarily contemplating passage through an unauthorised agent anyway, but it doesn't fit with this context. So the answer to my Lord's question is I don't accept the premise that there is some freestanding common law principle of service of notice that Parliament intended the words without prejudice to any other method of service to refer to in this context. Because I say it causes all manner of problems under this statutory scheme. So, Mills, I was going to move on from the features of the scheme itself. Actually, the second point on my list is still a feature of the statutory scheme, and I've kind of slightly covered it already, but it was to align myself completely with the formulation of Lady Justice Gloucester in the Court of Appeal in paragraph 44 about the three elements, and to say that that's borne out by the statutory language, which is a point I've already made. And I've already made the point, which was also part of my second point about the importance of making any approach to service work for both types of notice, and the concerns I respectfully invite the court to think about and consider in relation to a paragraph 2.3 of the scheme, where the date of service is the completion date, and that the appellant's approach is effectively to passport huge and open-ended uncertainty and dispute in relation to that that requirement, which is actually about creating certainty and creating a state of affairs contrary to the interests of a ratepayer, and which a further public body needs to take decisive action to give effect to. So those are the meat on the bones of the first and second sub-point in my part 2 of my submissions. My next sub-point is the proposition that the statutory scheme is highly regulated in terms of delegation. And may I deal with the observations of the court that if this is a new point that comes in late in the day, that colours its attractiveness.
No, it can be extremely attractiveness. It just means that it only occurred to you very late in the day, so it doesn't come clothed with obviousness.
Well, my lady, my provision, my submission on that is to accept the proposition but dispute the premise of the proposition. I say this is not a late point that's come in from me. This is a point that has emerged from the way in which the argument is shaped. And actually, the reason it's come into sharp focus here is because it needs the proposition that being advanced for why Lady Justice Gloucester was wrong to say it doesn't make sense to say that the receptionist is serving on behalf of the authority. When you look at the proposition that's put against that, it's undoubtedly inconsistent with the overall statutory scheme. And may I just make that good? So if I could just trace the argument very, very briefly through the various tribunals. I'll start at the upper tribunal. And if the court would please go to page A170, which is within tab 13, paragraph 47 of the President's decision, so the Deputy President's decision. So the Deputy President is dealing with Tadema Holdings, which is obviously with Townsend Carriers later on in that paragraph, which is obviously the
Which paragraph?
I'm sorry, my
47.
Lord.
47.
Paragraph 47 on page A170. And the Deputy President is dealing with Townsend Carriers in the second part of that paragraph, and which is obviously the foundation stone of his analysis and Mr. Coquelar's case. And he notes that he notes, if I could pick it up, the person to whom the notice in that case was given was found to be a general agent of the landlord and its associated company. So both the language and the context were different. So far, I agree. He then says, it's true that this case is concerned with service by a billing authority, not giving of notice by a party to a private contract. Nevertheless, in the absence of some specific restriction, and he says on modes of service in the statutory scheme, I do not accept that a different approach is required. So his approach was to note that it needed to be serviced by the billing authority, but say, as he understood it, there was no restriction on this permissive approach applying in this statutory regime. Lady Justice Gloucester differed from that, and one of the reasons that she differed from that, which I respectfully endorse, is to be found in paragraph 50.
Paragraph 48, I was just looking at the upper tribunal.
Yes.
Do you accept what he says at the second half of paragraph 48? That if the company secretary had attended the board?
I don't actually. On my framework that I respectfully say to the court, the first question is it one of the approved methods? No, it isn't. Then has it been agreed? No, it hasn't. Then is it a series of acts that represent service by the billing authority within the control of the billing authority? Well, no. The mere fact that the accident of the way in which it was received, which was totally outside the control of the authority, was 5 minutes rather than some period unknown between a week, and that it was handed in person rather than received by email, makes no difference to the analysis.
Well, that's why I asked you.
Yes.
I thought you probably wouldn't say that.
And my Lord, if I may say so, that what we're looking for here, whichever way it goes, is some principled framework, and because otherwise, in this context,
it
there'll be
seems to me that
chaos.
the electronic communication point is a bit of a side issue, because, the real critical thing is this agency point and the status of the person who received the notice.
Well, it's a further difficulty, I say, in the council's case. But it's never been the primary point. But I do say that actually in the statutory scheme it doesn't work either on its own terms. So even if I lost the agency point, and the court accepted that all that mattered was actual receipt, I would be able to say, well, yeah, but you lost that one as well because we didn't actually receive the notice. We received an email version of it in a context where the statutory scheme only allows that on a consensual basis and for different provisions.
Well, you're coming on to that.
Yes.
Yes.
I was just dealing with
That's your
my
next
Lord's
one,
observation. Yes. So I'm sorry, I got slightly sidetracked from, I was about to go to paragraph 50 of the Court of Appeal's judgment, and that paragraph 50 starts at A155, but the relevant bit is over the page at A156, and this is dealing with Townsend again. What Lady Justice Gloucester says, and the other judges in the Court of Appeal agreed, is if I can pick it up from, but this dictum does not, in my mind, justify any wider construction of the concept of service under paragraph 8 of Schedule 4A, so as to permit service to have taken place in circumstances where there was no authorised receipt by eco receptionist on behalf of the appellant. And then it's here that it comes into the reasoning, and no authority on her part on behalf of the respondent to serve a notice on the appellant. So so she wasn't authorised to serve the notice on behalf of the council, is what Lady Justice Gloucester said. That's consistent with her identification at paragraph 44 of the three critical elements. So what happens next is the appellant's appeal, and they try and answer this point. And the answer that they give to this point is to be found in two places. Firstly, at page A27, paragraph 50C, in any event, the Court of Appeal was wrong to hold that the receptionist was not authorised to effect service of the completion notice on behalf of the respondent. In handing the notice to the receptionist, the respondent's officer, that's the council's officer, clearly intended that she should pass it on to the respondent, as she duly did. The appellant must therefore be taken to have impliedly authorised her to do so. Now, as I understand that, the proposition is effectively that the Westminster Council impliedly authorised the receptionist to serve the notice. That's a challenge to the reasoning of Lady Justice Gloucester, and it begs the question, is that something that's lawfully permissible? To which I say, on a correct analysis of the statutory scheme, the answer is no, because it can't be delegated, and it doesn't fall within the permitted agency arrangement where the authority would retain control such that, properly analysed, it would be carrying out the function on behalf of the authority. But the way this comes into the frame is the appellant's challenge to the reasoning of Lady Justice Gloucester. The same point is made in the appellant's case at paragraph 39, point B, which is at page A61, and which we answer in our case at I think it's paragraph 70, where we draw together the analysis in relation to paragraph 39. So it's the council's need to deal with the Court of Appeal's observation that the receptionist can't be taken to be authorised to effect service on behalf of the council that brings into bear the delegation point. It's not a freestanding point. It's just a part of the statutory context that says this is restricted in this scheme, and also it's part of my submission that there's no meaningful analytical boundaries to the open-ended indirect receipt here that could be possibly capable of working in this particular statutory scheme.
What about dispatch rider?
Well, that would be an age that would be in paragraph 52 of our case, we accept the the agency. So the question is it a true agency arrangement where the council are in control? If they've got a contract of an enforceable contract that you do this and you serve it in this way, it's a completely different category of case. So I would say yes, because going through the analysis, the principled analysis, not one of the identified methods, let's move on. Is it on behalf, is it by the authority, is it agreed? No. And then third question, is it, paragraph 44, is it by the authority, on behalf of the billing authority, by the billing authority to the owner? Yes, it is. Why? Because it's within the permissible terms of delegation because of the Credit Suisse case, paragraph 52 of our case. So that's the distinction. We were mindful that we did not need to say and did not want to say that the council could not engage a process server or somebody of that nature, because that would be section 111 classic territory, agency arrangement controlled by the council, enforceable contract. The feature of this case, when one focuses on the position of the Eco-FM receptionist, is it's nowhere near that territory. It's an abdication of control for the timing and nature and whether it even happens of the passing on, where the council has got no remedy, and therefore, as a matter of law, it does not, I submit, it cannot represent service by the billing authority as properly understood in the statutory scheme and the established principles of local government law.
What if the council officer said to the receptionist, I would like you to make sure that this is transmitted to the owner of the building. Can you give me an undertaking that you will do that? And she says yes.
And they sign a contract there and then.
No signing of contracts.
Well, there might be scope for the principle of estoppel, but there might be difficulties with the principle of estoppel because here it's an unauthorised agent that's taking that step. So my Lord, it's not this case, but my submission, I think, if I need to jump one way or the other on the example, is that would fail the Credit Suisse test.
Because there's no contract between the...
Not a true agency situation. They're not truly acting as the council.
Where do you get that from section 111?
Credit Suisse. Should I take that now? Because it's obviously an important point in terms of shaping the argument. But if I can, I'll show you it as briefly as I can. But at paragraph 52 of our case...
I mean, I saw it in your case. I haven't looked at the...
No, well, can I show you that I'm not making this up as I go along. It's central to our case, and then show you where it comes in on the authorities, if that's acceptable. So, A84, paragraph 52, and then in that passage we make submissions about the concept of causing the completion notice to be served, luck rather than judgment. And we say the submission is the position is in the present case is materially different from, for example, a situation where a local authority contracts with the process server to carry out personal service of a notice on its behalf. Such service might be authorised by section 111 and not raise any questions of unlawful delegation. See the observations of Lord Justice Hobhouse and Lord Justice Peter Gibson in the Credit Suisse case. So can I just show you what that is by reference to Credit Suisse? So that's tab 36 of the bundle of authorities, there's actually there's also potentially a valuable passage from Lord Justice Neal on this. So the authority starts at A325 of the bundle of authorities, and I say at once, it's a very different context. So just if I can it's a very complicated case, if I can just try and set the scene and then go straight to the dicta in the interests of expedience. But it's effectively an attempt to enforce a guarantee given by the council where they had created a scheme to fund the building of a swimming pool and timeshare that in a sense sought to work around controls on borrowing in the local government legislation. And the decision in the case was that the bank could not enforce the guarantee because the scheme was ultra vires. And the bit that bears on our debate is the question of whether the company that had been set up to give effect to this was under the control or influence of the local authority. And it's in that context where the three passages about use of agencies and the difference between being in control and surrendering control come into play. But I say that each one of the judges make observations that fit in with what we've tried to formulate in paragraph 52 of our case. So if I could go first, please, to internal 347, bundle reference 347, which is from the judgment of Lord Justice Neal. Subparagraph G, he says, I do not find it necessary to decide whether in the absence of some statutory power there may not be cases where a council can lawfully use a wholly owned subsidiary under its direct control as a means of carrying out its functions. The company might then be the agent of the council. The point does not arise in this case. So he's contemplating there might be an agency style arrangement that reflects. So that's the least clear of the dicta I'm going to go to, but that's what Lord Justice Neal contributes. We didn't refer to that one in our case, but I just draw it to your attention for completeness. Lord Justice Peter Gibson is at A365. He refers at the top of the page to the council's functions under section 101 and section 111. And can I pick it up in A? In that section, as in section 111 of the Act of 1972, the references to functions must have their ordinary meaning as the duties and powers of the local authority. It is, of course, possible for a council, meaning the chairman and councillors, in the discharge of its functions to act through its own staff. It can also employ outside contractors. That, in my judgment, is permitted by section 111. But when such a contractor is used, whether to build a swimming pool or to run it, the arrangements must be such as to leave the local authority itself discharging its statutory function. And on the facts of this case, that wasn't so. My submission is that's the approach that should be adopted to the use of a process server or something of that nature. Is it properly characterised, the discharge of the function of servicing the notice by the council? If yes, section 111 will permit it. But I say that covers the examples that my Lord Kitchen was giving to me about process servers, etc. But it doesn't cover an ad hoc request to an unauthorised receptionist where there's no pre-existing arrangement and no authority to enter into it.
Well, that's pitching it a little high, isn't it? Because this is the receptionist in the building in issue.
But
is it not possible that one might say that the authority had a reasonable expectation, and it was certainly their intention that the receptionist should pass it to the owner?
Well, my submission is, well, could they authorise it? Would it be acting on? The question is on these authorities. Would it be acting on behalf of the council? My submission is no, because it's not an authorised agent.
No, I understand.
So one has to be a little bit careful about the step on the facts of this case to say, well, it was a receptionist in the building. It was a receptionist in a building that wasn't the principal office of the respondent. It wasn't their registered office. They didn't do business there. It was a facilities manager that was employed by to manage the building, but where there was no agency arrangement. And I say that what's fatal here is that, plus the fact that there's no recourse from the council, and that therefore it's not properly, it can't properly, on the facts, properly understood, be the discharge of the local authority's function of servicing the notice. The other dicta is from Lord Justice Hobhouse, and that's at 378. Sorry, that's internal page reference, so it's A378 is the bundle reference. Sorry, and it's to similar effect. If I pick it up at letter F on bundle reference A378, which is 359 on the internal referencing. However, without any such delegation, authority may employ contractors or contractors or agents. That is what is permitted by section 111. It is still the authority that is discharging its functions. The employment of a contractor or the use of an agent facilitates that discharge, but that's not what happened here under the present scheme. The company was not the agent of the council. It was not employed by the council. It had no contract with the council. The company was a freestanding entity trading on its own account without obligation to the council. Now, the context obviously is different, but I invite the court to substitute the eco-receptionist to that analysis. That eco-receptionist was not discharging the functions of the local authority when it emailed the notice to the respondent in whatever form.
Might I just put to you one other possibility? Supposing the receptionist said, well, I'm not going to tell you who the owner is, but I do know that a director of the owner, the managing director of the owner, is coming here in half an hour. And I'll give him the letter for you. No contract, no formal agency, but you have an expectation that it will happen. On your submission, that would not suffice.
Absent estoppel.
Absent estoppel.
Absent estoppel, yes. Yeah. And my lord, I make no apology for that, because what I say is that the greater good is the certainty of the scheme, and it's not as if there's difficulties in finding a method that's easy to do. And if there are difficulties, there's a fail-safe in there. And on Lady Justice Gloucester's analysis, which I don't challenge, there's also a very large ability to take sensible and prudent steps. But that would be an imprudent step. In that circumstance, the prudent counsel would say, well, I'll wait for half an hour, or I'll come back in half an hour, and I'll serve it myself. because it would not be them discharging their functions to abdicate to the receptionist something over which they had no control. And I say that's what local government law indicates as the permissible scope of section 111 as the discharge. Now, that is all layered into a statutory scheme that contains quite a lot of regulation, which I do need to show the court. But I took that point out of turn because this court is understandably interested in a certain framework. And I say that actually the application of these principles provides that certainty. It makes the scheme sensible and workable. And the facts of this case are completely outside of what the sensible bounds of service by the authority is, properly understood. So that also, I hope, deals with my Lord Carmer's question about what the limits are. I was going into the delegation context. I deal with this in our written case. Can I just deal with the primary provisions speedily, if I may? So the submissions for the court's reference in our written case are at paragraphs 18 to 27. And the relevant provisions are in the bundle of authorities at, at tab 28. We need to go to the 1994 Act, briefly, the Deregulation and Contracting Out Act of 1994. That is tab 28, page 231, please. And Mr. Cocklar has shown the court these briefly, so I will deal with it. I think he has. No, I don't think he has, sorry. I don't think he has. So I think this is the first time these have been shown to the court. But section 70 is conferring the ability to have a function exercisable by a third party. And orders can be made under section 72, and where such orders are made, the effect of section 72.2, which is on page 235, is that the function that has been so conferred shall be treated for all purposes as done or omitted to be done by the local authority. So effectively it's treated as the act of the local authority.
So is this relevant here? I mean, Does this apply to the dispatch rider that he has to bring himself with him?
No, it doesn't. So the overall scheme is you've got a specific intervention, which I'll show you in the rating context, which assumes the delegation of certain functions, not applicable here, but you do have the Credit Suisse general local government law principle about whether it can be...
Section 111.
Section 111, yeah. Which I've made separate submissions about.
This doesn't detract. I mean, as I understand it, Mr. Cockle, you're writing on Section 111, and you say no because of Credit Suisse.
Yes, well, that's true.
But we don't need to get into all this.
Well, except that he's relying on it. He's relying on a general principle of local government law in a context where Parliament has actually bothered to make some very specific provisions delegating certain functions of rating to contracting out, and it is noticeable that this is not in there. But I accept that that's not
noticeable. The dispatch rider is not in there either.
No, but you wouldn't expect the dispatch rider to be.
I wouldn't expect the receptionist to be in there either. I mean,
no, but
I'm sorry, I don't want to take up time. It just seems about getting bogged down in complexities of local government law, which really don't come into this case.
What one might expect is a permissive approach to, because these provisions do cover service of notices in the demand notice context, but they don't cover completion notices at all. And I accept that doesn't get me home if the court is with Mr. Coquelin on Section 111, but I do say it's part of the context in which, as a matter of statutory construction, this court is asking itself, how does the submission of Mr. Coquelin's client as to the expansive approach to indirect service, how does that fit within this scheme? And one feature of the scheme that I do rely upon is the highly regulated nature of delegation. And that's as far as the point goes, and it's a relatively short point. So the scheme is Section 70, and then it's the Act of the Authority under 72.2, and then the regulations are to be found, again, it's dealt with in our written case, so I'll take it relatively shortly, but the short point is, if the court would go to A262, there's a heading there, Part 6, non-domestic rate contracting out, and then there's the identification under Article 49 of certain functions in relation to the collection and enforcement of non-domestic rates, and the detail of it is in the following articles. For example, demand notice, etc., where if I look at Article 51, subsection 3, an authority may authorise a contractor to prepare and serve demand notices and any further notice which is to be treated under the regulations as if it were a demand notice. And there's provision in relation to certain collection and enforcement notices in the other provisions, including reminder notices, provisions relating to executors and administrators. But my submission is, or my observation is, that the whole of the completion notice regime is not included in this, and there's no contracting out of that function. So I accept that doesn't mean we're not in. We've still got to think about Section 111, but that is a feature of the scheme that Parliament is looking carefully at who can act on behalf of the authority, prescribing regulations, and that is a factor that I say that tends against the expansive approach to indirect service that's relied on in this case. I just draw attention to A272, Article 64, in relation to the function of giving or serving a demand notice or any other notice or any request of other document. A contractor shall ensure all documents are given or served in the name of the authority, A272. So permissive approach, but has to be in the name of the authority. In a sense, that fits with the general principle, is this an act of the authority? And I've made my submissions in relation to Credit Suisse ahead of time, but this is part of the context to say delegation is part of the statutory framework. The fourth sub-point, if I could just move on, is the position in relation to electronic communications. And I do say that the provision here in if we go to tab 29 of the bundle of authorities at A238, 239, in fact, if we could go to A240, the power to modify legislation. So the purpose of this is authorising or facilitating the use of electronic communications. See subsection 1. The purposes relate to the doing of anything which under any provision is required to be done or may be done or evidenced in writing or otherwise using a document, notice or instrument. So it's wide enough on its face to cover, I respectfully say, the service of a notice. The provisions that have been made by Parliament in relation to non-domestic rates are contained behind tab 32, and the features of them, if the court would look at page A275 and A278, so if A275 is relating to non-domestic rating demands notices, and they may be served using electronic communication, but only where effectively there is an agreement to serve electronically, or there is the ability to deem agreement to have been given. So they are consensual in their nature in relation to the service of demand notices. And I've already made the observation that demand notices are bilateral. There's no parallel role in relation to the valuation officer. And the same provision applies under Article 7, or the same scheme applies under Article 7. It's based on agreement, and you can see that in absolutely clear terms in the explanatory note to the regulations that they effectively they provide for service by electronic communication on a person who has agreed to accept electronic service. So in this statutory scheme, Parliament has got involved in the emerging use of email electronic communication. It's taken action in the non-domestic rating context. It has enacted a permissive scheme, but a permissive scheme that is limited to what it applies to and is entirely based on the provision of consent. There's actually parallel provisions under the Companies Act, which were referred to in passing by Lady Justice Gloucester in her judgment. There also, the Company Communication Code is predicated on consenting to the use of electronic communication. I say it is an unprecedented step for there to be valid service of a completion notice electronically where there is no consent to that. That is a new step that's not backed up by any authority at all and is inconsistent with the express provisions of the statutory scheme. Now, the only indicator against that in the authorities is the position in relation to faxes, and they stem from the Hasty case, which was a pragmatic extension of that, which was reluctant, see Lord Justice Lloyd, but it was in the absence of a regulated basis. So they were filling a gap. Here, my submission is there's absolutely no gap to fill. Now, my Lord Carnworth asked about the PNC case and had the Court of Appeal had that cited, is it dealt with? And that is the strongest indicator of a permissive approach to faxes, because they do refer to the Electronic Communications Code. But if I could just go to that very briefly whilst I'm dealing with this point, it's very different, because the reasoning is, well, service by fax is something that was established before the Electronic Communication Code came into play. So we've already got established principles to draw upon, and that is a material distinction. So if I could go just show the court why I say that briefly, which is the PNC case, which is tab 44. And I have in mind in particular paragraph 16 from the Vice-Chancellor's judgment there, where he received what he regarded as cogent submissions relating to the Electronic Communications Act, but he said, notwithstanding the cogency with which
What page are you on?
I'm sorry, A452.
452, thank you.
And it's paragraph 16 of the judgment, my lady. Notwithstanding the cogency with which the arguments were advanced, I do not accept them. First, the fax has been in general use for much longer than email and internet communications, with which the Electronic Communications Act of 2000 was primarily concerned. Though the fax is included in the means of the electronic communication which the Act and orders made under are concerned, it is not, I think, to be regarded as introducing the fax as a permitted means of communication for that which had been done on a case-by-case basis or so over the preceding 30 years or so. I say this is materially different. The Electronic Communications Code is absolutely to do with introducing on a limited and basis the use of electronic documents. There's no pre-existing precedent for receipt of documents by email. In this particular context, it's carefully regulated in certain non-domestic functions and only on a consensual basis. And there's no pre-existing body of case law to draw upon that supports its use. So we are in unprecedented territory that's foursquare within the regulatory context of Parliament's regulation. And in that context, I respectfully say it simply doesn't fit within the statutory scheme to authorise open-ended use of electronic communication by reference to the words without prejudice to other methods of service, because it doesn't fit with the overall statutory scheme. And I say that that's why PNC can be distinguished as a fax case, pre-existing body of cases, and also the very express qualification that the fax effectively is not the main focus of the electronic communications and pre-existed before then.
What other means of communication are there apart from electronic communication, fax?
Email, and I think web sort of use of...
Yes, but in the statutory code where it says by other means, I mean, if you exclude email...
Well, my Lord, the answer to that is in Lady Justice Gloucester's judgment. It's not necessarily electronic communications. It's authorised agent, for example, was not one that's expressly mentioned in any statute.
Yes, but you're still getting the document there.
Yes.
There's no other means of receiving the document other than by its presentation by the council officer or by an authorised delegate.
My Lord, I say there isn't. I mean, there's a moot point about whether service of a completion notice by fax might be valid on the basis of hasty. That's not this case, but my submission is it's contemplating the physical receipt of the document.
So by other means refers to receiving it from an individual who has been delegated. That's the extent of the reach of the rubric by other means.
Forgive me, the rubric of without prejudice to other methods of service in paragraph 8. Well, it's a bit wider than that, my Lord, because it obviously covers, for example, the express provisions under section 233 of the Local Government Act. It would cover all provisions under the Companies Act, and it would, as I've submitted, it covers all consensual arrangements.
Well, I suppose you can say that if there has been agreement about receipt of electronic means.
Well, my Lord, yes, because that would be covered by agreement. Exactly right. That is true. But the sharp point of construction for this court is whether one can read into that requirement a permissive approach to a non-consensual use of electronics when in a statutory scheme that covers almost exactly the same territory, the regulation of non-domestic rates, there is a limited approach that's only certain notices that are much simpler. They're not the multi-party, they're bilateral, and consent is at the heart of the scheme. And I say it's contrary to the scheme to introduce that, and there's no need to. There's no, it's not as if it's difficult to serve a completion notice. There's all manner of ways in which you can do it simply, and if you have trouble, you've got statutory powers to assist you. Section 16 of the Miscellaneous Provisions Act 1976, which allows...
No one's suggesting there aren't ways they could have done it better.
Well, no.
But you have to be saying that insofar as Hastie and McMahon extended the common law, in the context of fax and by implication other forms of electronic communication, it's sort of implicitly cut down by the specific legislation to which you've now referred us.
Well, first of all, the context of them where they were filling a vacuum, so that there was no...
No, but they did it, and
they've
established this extension of the common law, which, had it not been for the Electronic Communications Act, you would say, well, there it is. But you have to say that the Act has sort of somehow cut down the common law in that respect.
No, my lord, I don't, because they didn't extend it to email. Those cases didn't extend it to email at all. So...
Talk about new forms of communication, don't they?
No, they're all about facts. They start from a case that's about a list of documents, and then there's a limited and incremental extension of it. None of them deal with email at all. In relation to email, in relation to fax, there was a vacuum to fill. In relation to email, there is no vacuum because Parliament has acted. And Parliament, I'd respectfully say, has obviously acted on the assumption that there isn't this indirectly permissive approach under common law, because if it did, it wouldn't make any sense for it to facilitate the use of electronic communications by allowing it to happen where there is consent, because on the analysis that would be restricting rather than permitting. So it would make a nonsense of
as a matter of practical reality, there was no possibility of getting consent because you were withholding your identity.
well, on that point, which obviously has influenced my law. But in fact, if I may, in fact, if one looks carefully at the facts as found by the President, what happened was, on that particular point, is that there was a request of the agent. The agent said perfectly responsibly, I'll have to check with my client. He did check with his client. His client said only if I have to, but actually, factually, the billing authority never asked again. So there wasn't ever actually a refusal that was communicated. So, my lord...
So there was a refusal in the ether, but it wasn't communicated.
But I think the principles...
I'm not sure that blunts the point terribly, Mr.
Well, just wouldn't want my lord to consider it on an incorrect basis. So in relation to electronic communications, my submission is there's no equivalent case law of hasty that applies to emails. There is a statutory scheme that's obviously regulating. It's one that, on the face of it, is seeking to expand, and therefore the use of this does not fit into the statutory scheme. So I say those four features, which I've developed, of the deeming taxation, the three elements, the restrictions on delegation and the restrictions on electronic communication, are very strong indicators against the expansive approach to indirect service upon which the appellant's argument is based and upon which the upper tribunal found to exist, but which I say was rightly overturned by the Court of Appeal. Against that is actually simply the Townsend case, the obiter dicta in the Townsend case. And I just observe, without, I hope, needing to go there, it's about a clause to give notice in a lease. The facts is that there is dealings between the parties as if they were landlord and tenant. The whole case turns on general agency. Yes, it's right that there are some comments on the giving of indirect notice in the context of construing a lease. There's no reasoning attached to the observations at all, and the case itself was an agency case. So I don't think my learned friend is able to identify any example, even in the landlord and tenant context, of a case that was decided about the indirect communication through an unauthorised agent. Certainly none of them that have been drawn to the court's attention. I do accept that there is the obiter dicta of the Vice-Chancellor in Townsend in that context that on one reading would apply, but it's not something that was ventilated in the context of that case because that was a general agency case. There's also, in Galinsky and McHugh, one of the observations of Lord Justice Slade also suggests a broader approach, but again, not rooted in any findings of unauthorised agency. But even if the position is acceptable in the landlord and tenant context, I say moving that principle into this context causes very considerable disquiet to the workability of the statute. It is contrary to certainty, it doesn't manifest service by the billing authority, and also it effectively is, I say, it doesn't recover from the fact that EcoFM are not the authorised agent. So may I transition to...
May I just ask you one question before you do?
Yes.
And it's in connection with the PNC Telecom case. And is it fair to say that the particular problem with which the court was concerned was the provisions in the Companies Act under which the word deposit was used, and consequently the communications order was needed to address that particular usage?
Certainly is correct that the term was deposit.
Yes.
That certainly is correct. I'm not sure that the reasoning turned on deposit meaning anything different. So if one looks at A451, paragraph F, the debate is whether the requisition was deposited for the purposes of the Act. Council PNC has demonstrated how the Companies Act uses a variety of verbs to describe essentially the same process, namely delivery, send, furnish, give notice and deposit.
Yeah.
So my Lord, I don't think the language of deposit was the relevant distinguishing feature, but my Lord is absolutely right that the relevant provision was expressed in terms of deposits. I do, sorry, before I leave my part 2, and I've covered most of my part 3 and 4 anyway, but I'll just go over that briefly. If I could just mention Tinkler. So Tinkler obviously is an upper tribunal lands chamber. It is obiter, but what it does show, I respectfully say, is that in a taxation context, where actually all that was concerned there was the opening of an inquiry, which is a less draconian step than the serving of a notice that determines the basis of rating against the interests of the ratepayer. The approach there was that passing on even from an authorised agent would, passing on by a solicitor who wasn't authorised to accept service would not have amounted to valid service. So there was a restrictive approach to indirect service in that taxation context. Now, I say that this taxation context has got many features that stand on their own, but it is of interest that on the current state of the authorities, there is not the permissive approach in the taxation context.
But we don't know whether it was passed.
No, but we don't, but the observations are very clear that it wouldn't have made a difference. And so, my Lord, just drawing threads together, I say Townsend is a different context. It doesn't fit with our statutory scheme. It's inconsistent with the income tax context, and also all of these landlord and tenant cases are bilateral arrangements in private law, and I say here we're in neither of those territories. It's not purely bilateral because it also has to communicate to the valuation officer, and it's not a private law context, it's a taxation context. So in the if I can move on to part 3 of my submissions, which is the problems that result from the appellant's approach and the upper tribunal approach. And I can deal with this shortly because I have foreshadowed much of this in the discussion that's been facilitated by the court as we go through the second stage.
Oh, you're far too kind.
Very enthusiastic facilitators.
The problems with it are, if we focus on the position of EcoFN, they are, on the findings of fact, an unauthorised agent. So that's paragraph 17 of the agreed statement of facts makes that clear. They are an unauthorised agent. They're not authorised to accept service. The problem opened up in paragraph 48 of the upper tribunal's reasoning of the idea, well, even though they're not an unauthorised agent, they're not a complete stranger. That is something that is incapable of having sensible boundaries being built around it. And it is obviously going to be incredibly contentious to litigate because it's not clear what not a complete stranger means. Whereas it's absolutely clear on any given facts whether somebody is authorised or unauthorised to accept service. That's something that can be supported by documents, by evidence. In my submission, that's the key distinction, authorised or unauthorised agent. If we collapse that distinction by saying, well, they're not a complete stranger, Why is a receptionist different from a solicitor who has got general conduct of the matter but not authorised to accept service? If they then pass on for information to their client the notice has been received, then all of a sudden we've got indirect receipt, and we've collapsed one of the fundamental principles that solicitors, rating agents, property managers can indicate the extent of their authority to accept service. This expansive approach to indirect service leaves those clear lines in tatters, and the only articulated basis for doing that is this notion introduced in paragraph 48 of the Deputy President's reasoning that they're not a complete stranger, but that's not a test that offers any meaningful boundaries. The right boundaries, I respectfully submit, are the ones identified by Lady Justice Gloucester and the Court of Appeal, whether they are authorised agents. So that's one element of the ECO-FM. The other element is the point I've developed at length, is that they can't possibly be said to be authorised to effect service on behalf of the council. I've shown how that's come into the debate, and I say it's inconsistent with the delegation provisions under the contracting and deregulation provisions, and it's also inconsistent with the concept that effectively, in order to be on behalf of the council, it must be within the council's control. And the line I commend to the court is the Credit Suisse line of, is there some accountable control here such that it makes sense to describe this as an act of the authority? So the problem with the attempt of the Deputy President to introduce indirect service here is that it doesn't work on either basis when we look at it through the prism of the unauthorised recipient of the notice, the receptionist on ECO-FM. It's gone to them, it's been delivered to them in the Tadema sense. They're not authorised to accept service on behalf of the respondent, so it fails that. And they then, insofar as the case moves to the onward transition, which it does on the Deputy President's reasoning, he makes that very clear in, I think it's paragraph 44, he goes on to say it's all about the subsequent transmission. Well, the problem with the subsequent transmission is that's not an act of the billing authority. So there's never a position where the three requirements indicated by Lady Justice Gloucester correctly in paragraph 44 all exist. And my learned friend's own case is built on the proposition from the conventional notice cases that you serve if you cause the notice to be delivered. Well, as we submit in paragraph 52 of our case, even applying that ordinary test, the council failed. They didn't cause the notice to deliver. They gave it to somebody who had no authority to accept it and no authority to serve it. What happened after that was utterly outside of their control and cannot properly be described as them causing the notice to be delivered. And the third basis on which it breaks down, I'd respectfully submit, is that the approach to electronic documents is not consistent with the statutory scheme. Now, it's true that the Deputy President considered that that wasn't an obstacle, but he did so effectively in one paragraph of his decision with no reasoning attached to it, paragraph 49. Although the Court of Appeal didn't find it necessary to decide this point, there is an indication in Lady Justice Gloucester's judgment that they were minded to accept the submissions that had been advanced but hadn't had the benefit of full argument. Obviously, this court may need to decide that point, and obviously it's been far more fully argued in the case and oral submissions before this court, and I've made my submissions in relation to that. May I just spend a moment, because there is a correlation between Mr. Coquelar's case on behalf of Westminster and the Deputy President's reasoning, by indicating to the court where I say the Deputy President's in the upper tribunal's reasoning goes wrong, in order to draw my submissions together by reference to that. So if I could invite the court, please, to turn to tab 13 and page A167. the issue is, it's issue 2, so it's really paragraphs 38 to 51 that deal with this point. At paragraph 39, I just asked the court to note that the way it's expressed there is the purpose of the completion notice in this case was to inform the owner of the appellant's belief that the building could reasonably be expected to be completed within the time specified in the notice. I accept that that was a purpose. I don't accept it was the purpose. The purpose also was to create a certain mechanism for enabling taxation on a deemed basis that required communication on a certain basis to the valuation officer as part of the function of that notice. The debate then, as I have foreshadowed just a moment ago, if we go to paragraph 44 of the judgment, we see that the debate shifts to the onward transmission. So at the last sentence of paragraph 44, the Deputy President says, for the purpose of this appeal, whatever had been argued before the President, that's in the valuation tribunal, the appellant did not rely on the delivery of the document to the building itself, but on its subsequent onward transmission to the respondent. So it's the act of the receptionist giving it to the respondent that is the critical part of the analysis, and I've made my submissions about why that's not service on behalf of the authority for the reasons that I have canvassed. In paragraph 44, before we get to that stage, there is the finding that there is no, the receptionist employer was a facilities, in 44, in the fourth line, the receptionist employment was a facilities management company and neither it nor its employees had actual or ostensible authority from the respondent to receive such documents. So there's an unequivocal finding on the face of the Lands Chamber of no actual or ostensible authority to receive the notice, which is why the debate shuffles along to the onward transmission. 46 is an intriguing paragraph in the Deputy President's reasoning, because if I ask the court to draw a line either mentally or physically at the top of page A170, and the second line before the words "what I find more difficult," in the section of that is before that line, I say that is the best possible encapsulation of the real dangers that uncertainty brings in this statutory context. And I say that effectively the focus then on eventual receipt contradicts and undermines the emphasis on certainty. If you're going to accept the force of the certainty policy debates, then they necessitate arriving at a situation where clear lines are drawn. The vice of what follows from what I find more difficult is it introduces a concept that has no boundaries, where all that matters is eventual receipt, no boundaries in terms of remoteness, no boundaries in terms of time, no boundaries in terms of whether physical or electronic. It's the antithesis of certainty. And it's not as if the Deputy President has said the certainty issues don't have force. He accepts they have force, he articulates them very, very clearly, and then I respectfully say he wrongly undermines them by having such a permissive approach. Then paragraph 47, which I've already foreshadowed, he acknowledges the difference in Townsend in terms of that it was an L&T case. This case is about service by the billing authority, but he never grapples with the implications of that, which Lady Justice Gloucester did in the Court of Appeal, by the fact that it just doesn't make sense to say that the onward transmission by EcoFM was serviced by the billing authority. So he misses that critical point, and the Court of Appeal was right, I say, to ask that question. As soon as you focus on that question, there's only one tenable answer to it, which is that EcoFM are not authorised and cannot lawfully serve the notice on behalf of the billing authority. And then at 48, we have, again, I've already made my submissions on this, but the formulation is that somehow you can draw a line between unauthorised agent and authorised agent that says not complete stranger, and that is a category that's capable of having meaningful boundaries. My submission is it isn't. That's a mistake. The line is authorised agent. If not, I respectfully say end of case, and certainly
I think
not.
we might have got that point.
I'm just trying to relate the submissions to the analysis, my lady, that's where the complete stranger point comes in. And then the reasoning on 49 on electronic communication, I respectfully indicate there is no reasoning. So, my lady, then just drawing those threads together by reference to the policy considerations.
We're debating whether your time is up, Mr. Kolinsky. It isn't according to me.
I think I've got until 22.
I think you've got until 22 too.
Right.
However, I don't encourage you to take it.
Okay, well, I'll do my best not to. It's only 9 minutes, my lady. So the end is certainly in sight, my lord. I will take this shortly because I have drawn these threads together. But
don't take any sort of encouragement from what I've just said.
No. Other than to finish quickly, I won't, my lady. The policy considerations that we sketch out in our written case. I say there are 3. There's the certainty and clarity point, which is there's unanimity among. I set this out in paragraph 55 of the written case. There's unanimity from all of the tribunals below. The valuation tribunal at paragraph 49. The upper tribunal at paragraph 46, the Court of Appeal about paragraph 49, of the importance of certainty in this context. I say that's a critical consideration. We need to make the scheme workable in a context where there are 3 actors and where we need to know precisely when service has been affected. That's set out, I've developed that in my submissions, and it's set out in writing, and as I say, it was accepted by all of the tribunals below. I say that's an important policy consideration. My second one, paragraph 58 of my case, is the question of speed. The statutory language requires service as soon as reasonably practicable. It doesn't contemplate a gap between the service of the notice and its, or the attempt to serve the notice and its service. The whole process is meant to be that this is quickly brought to the attention of the ratepayer, and then the decision is taken as to whether to exercise the appeal rights. And the third policy one is a point that I've not developed in detail in my oral submissions so far, but I do strongly rely upon the observations of Lady Justice Gloucester at paragraph 53 of the judgment, that effectively the difficulty in this case of the council's approach is that it erodes the distinction between those with authority to accept service and those with no authority to accept service. And as we say in our written case, we say that does put the solicitor who would receive a notice, the rating surveyor who would receive a notice, the property manager who receives a notice, that they're not formally able to accept service, but they may have an obligation as a matter of contract or as a matter of professional duty to pass that notice on to their client. If that then might constitute indirect service, A, that is a radical development of the law, and B, it puts them in an invidious position. My learned friend simply says, well, they could just send it back. Well, there may be circumstances in which they could just send it back. There may be circumstances in which there are contractual obligations to pass on, where effectively it erodes and collapses a critical distinction that goes back to Saffron Walden in the 19th century, that people can indicate the extent of their authority. The vice of this is that in the pursuit of what's perceived to be a fair answer, that principle is eroded. That is very significant collateral damage to the law, which would be felt well outside non-domestic rates. I would say it would be a significant step in the wrong direction, and it's an important policy consideration. My lords and my ladies, I haven't dealt. There's a couple of cases I haven't dealt with, so just deal with them in the last moments. the Provident case, which is the question of delegation. It's intriguingly similar in its context, but actually all it's about is delegation within an authority. So it doesn't actually add anything. It's helpful for the court to be aware of the House of Lords decision, but it doesn't deal with any of the issues in this case. And over the short adjournment, we have read the Newcastle and Hayward decision, or reread it, because we formed the view that it was of a different context, and it isn't transferable so far as any part of our case is concerned to the current context. So, my lady and my lords, our submission is that the Court of Appeal were essentially right to identify the problems that they did in the open-ended nature of the Deputy President's approach, and in putting that case before this court and commending that case to this court, the appellants are advancing an approach that doesn't fit in this statutory context, doesn't make sense, will cause very considerable difficulties, doesn't fit with the limits on electronic communication, and also, as I've indicated, would put authorised agents who express the limits of their authority in an invidious and unwelcome position. And I respectfully say the Court of Appeal were right for the reasons they gave. Unless I can assist further, those are my submissions.
Thank you very much indeed, Mr. Kalinsky. Mr. Wilcox?
I'm grateful. My own friend, I have just a few short points. My own friend began by taking the Council to task for its failure to adopt a Plan B and serve a fresh notice. In relation to that point, like Sir William Blackburn in Townsend's, I can really only confess and avoid. It wasn't done. I can't really add very much more to that, other than that it isn't directly relevant to the issues that this court has to decide. My own friend took the court to the provisions relating to the service of completion notices in respect of buildings that are complete. And in particular, there was some discussion about paragraph 2, subparagraph 3, which is at page 224, tab 27. And my own friend pointed out that the date that the authority has to propose as the completion day in a completion notice relating to a building that is complete is the date on which the notice is served. And he highlighted what he saw as the difficulties that could arise out of that if my interpretation with regard to service was right. There are two possible answers to that. It's probably not necessary for the court to decide it, but there are two possible answers to it. One is the answer that my Lord Carnwath touched on, that in this context the word served could be construed as referring to the date on which the authority takes the step that sets in motion the process whereby the notice is delivered to the intended recipient. The other possibility is to say that when an authority serves a completion notice in respect of a building that is already complete, it simply has to make sure that it adopts a mode of delivery, a method of delivery, which gives it certainty as to the date of delivery. And that can be personal service, or perhaps one of the methods, or one of the methods specified in paragraph 8. It's not a provision which is glaringly inconsistent with our interpretation. In relation to the, there's been much discussion of the position of the receptionists, and Lady Justice Gloucester's observation that she was not authorised to effect service on behalf of the billing authority. I should make it clear that the position that we've adopted in both in the grounds of appeal and in our written case is that the authority, Westminster must be taken impliedly to have authorised her to pass on the notice to the building owner. But that is not essential, I should like to stress, to my argument, even if there was no such authority. As I indicated earlier, it does not form a break in the chain of causation that led to the notice coming into the hands of the intended recipient. I referred to the example that we give in our written case of the helpful neighbour who delivers the document to the correct address. My Lord Carnworth gave the example of the notice being put in the bin by the receptionist and then being fished out by an officer of the company. Obviously, in neither of those cases can one speak of an authorised action, because it was not an action that was foreseen by the billing authority. The billing authority didn't foresee that the person commissioned to deliver the notice was going to put it through the wrong letterbox. It didn't foresee that the notice was going to go into the bin. But what matters ultimately, as the Vice-Chancellor put it in Townsend, is that the notice emanated from the billing authority and that it found its way into the hands of the intended recipient. I'm also not trying to create a category of person somewhere in between the fully authorised agent and the total stranger. I, in my submissions, took issue with the characterisation by the President of the Valuation Tribunal that the notice had found its way into the hands of the of UKI by luck rather than judgment, because in my submission there was a reasonable expectation that the receptionist would pass it on to the building owner. But ultimately, analytically, my argument does not depend on there being this intermediate category of person who is not a fully authorised agent, but who is equally not a complete stranger to the intended recipient either. As to the matter of delegation, my primary position on that is that what happened did not, in fact, involve any delegation by the billing authority of its statutory functions. And I rely on the Provident case, the approach adopted by the House of Lords in the Provident case. In relation to that, it simply wasn't, what happened in that case simply wasn't delegation. What happened in this case wasn't delegation of the statutory function. But if, insofar as that's wrong, then I do rely on section 111. And my own friend's submissions on that sought to draw a distinction between a third party such as my Lord Kitchen's dispatch rider, with whom the authority has a contract, and a third party such as the receptionist, who effectively volunteers to effect, for no reward, to effect delivery of the notice. In my submission, the terms of section 111 are wide enough to cover both those scenarios. In both instances, it can be said that the actions are incidental to or conducive of the discharge by the authority of its functions. It's not given as an example of something covered by section 111 in the Credit Suisse case, but that's because it's simply it's not the scenario that arose in that case. The passages relied upon by my learned friends from the judgments of Lord Justice Neal and Lord Justice, forgive me, Peter Gibson, I think it was, are not, and Hobhouse, in my submission, are not intended to be exhaustive statements of what is covered by section 111. It would be very strange if the applicability of that section turned entirely on whether or not there was a contractually enforceable obligation in existence. Of course, the relationship of agency doesn't necessarily presuppose a contract. It is often in an agency-type relationship, one has a contract, but it's not an essential ingredient. It is first and foremost a fiduciary relationship. Now, I'm not suggesting that there was a fiduciary relationship between Westminster and the council, between Westminster and the receptionist. The position of the receptionist is really, from an analytical perspective, analogous to that of my Lord Kitchen's dispatch rider, save that she wasn't charging for her services. In relation to, finally, in relation to service by electronic means, I of course accept that both Hastie and Jenkinson and the PCN case were concerned with service by fax, but the reasoning, the underlying reasoning of the Court of Appeal in the one case and the Vice-Chancellor in the other for treating service by fax as good service, and my submission applies equally here. The ultimate result is the same. The recipient receives that which the giver of the notice intended him or her or it to receive. And there is, my submission, no good reason for distinguishing between fax and email on that basis. And finally, my learned friend criticises our analysis because he says, well, it's impossible to tell where the boundaries of it lie, and it creates uncertainty. In my submission, that is wrong. There is a clear test. Our approach adopts a clear test, which is that of actual receipt. If the notice is received, then it is treated as having been served. By contrast, the approach adopted by my learned friends and by the Court of Appeal is one that still leaves considerable uncertainty over what the concept of service means in the context of this legislation. When my learned friend was pressed on the meaning of the words any other mode of service, he accepted that it would include any other mode of service authorised by statute, any other agreed mode of service, and then the final sweep-up category was something along the lines of, well, anything else that could be characterised as service by the authority. Well, that is rather begging the question. Because it still begs the question as to what service means, and it doesn't give one a clear test or set clear parameters as to what service means in the context of this legislation. The difficulty with the approach of the Court of Appeal is that it is essentially negative. The decision is effectively, well, whatever service means in this context, this isn't it. That, in my submission, is unhelpful, unless I can assist the Court further.
No matter now, did you find the answer to my query about the market?
My Lord, I'm afraid not yet.
No, if you can do it, I'd be interested, but don't.
Yes, of course. Mr. Wilcox and I did attempt over lunch, but it's not entirely straightforward.
We'd given you a few things to do over
Yes.
the adjournment, so you are to be... you can be forgiven for that as long as you provide us with an answer, my Lord with an answer, and we'll also look at it with great interest.
I haven't mentioned the case that the President mentioned at the outset. I too have looked at it over the short adjournment. It does seem to me that it certainly
I think
certainly
it's
doesn't
more
harm my
interesting,
case.
it's more interesting that we were not referred to some of the cases that you've referred us to than the other way about.
Yeah.
But, at least that was my impression. There are a few remarks about policy which might or might not be of some assistance to somebody. I know not. Anyway, you obviously don't wish to make any representations about it on either side. So that's fine. I think you've been asked everything that we wish to ask you, so thank you all very much indeed. Those who've been on their feet and those who haven't been on their feet but have no doubt contributed to the preparation of the arguments that we've heard in this interesting, I can't call it a little case because so much money is involved, but it's a little point. And we shall go away and work out what the answer is. Thank you. Court will now adjourn.